Hi there, and welcome to this short examination of the American judiciary, federal judiciary to be exact. Now, courts are important because they settle disputes between people, right? We've learned that with Locke, we've learned that with 51. The federal judiciary can interpret the meaning of laws, apply laws to these individual cases, and decide whether laws violate the Constitution. All right? All power shall extending to all cases in law and equity arise under this Constitution, according to Article 3, Section 2 of the Constitution. Now, this is Article 3 of the Constitution, the federal judiciary. Now, to be a federal judge, you have to be nominated by the president, be vetted by the Senate, and take a position. There are about 870 Article 3 judges. There are 870 authorized Article 3 judges. So, we have the district level judges, the appellate level judges, and the Supreme Court level judges, right? Now, there are 673 district court judges spread across 94 district courts that are spread across America, all right? Now, the organization of these different districts are called circuits. There are 13 circuit courts in America, okay? Of the 13, 12 are called regional courts, and in those 12 regional courts is where the 94 district courts are located. Of the 13 is the 12 regional plus the federal circuit court. Okay? Finally, we have the Supreme Court with 9 judges. Now, the district courts are called the trial courts, or courts of original jurisdiction. Trial courts or courts of original jurisdiction. To have original jurisdiction means you have the power or the authority over most cases. They start with you, right? So they're the trial. They're what you're used to watching on TV. There's the judge, there's the jury, there is the defense, there's the prosecution or the petitioner and the respondent. All that's the how the district court works, right? It's where the trial actually takes place, all right? And they have jurisdiction on nearly every case. Now, what do these guys next to do? Appellate court. Let's say I lost my case. I have now the right to appeal, all right? Their job is to review how the trial took place. Are there any irregularities, right? Are there any constitutional questions that arise from this case that need to be reviewed, okay? So that's what they're doing. And they are benched judgeships or panel judges. So you have 3 judges. You have your side and their side. It's not a new trial. There's no trial. There's no jury. Their job is review. Now, the Supreme Court with 9 members acts in the same way in that their job primarily is to be an appellate court. So cases get to them through appeal, right? And they choose their own docket. They don't have to listen to every case, all right? They choose their own docket. And so their job is to be a multi-member panel judgeship where they are reviewing the same things. Are there any technicalities? Are there any irregularities? And there any constitutional issues that arise? So this is the structure of the federal judiciary. These judges have life tenure, right? They cannot be kicked out of power other than in bad behavior, which that will have to be defined by them. What is bad behavior? They can be impeached. There's only one judge who has ever been impeached in American history at the beginning of this new constitution, 1805. Samuel Chase. He was impeached under the Articles of Impeachment in the House of Representatives. But the next step of impeachment is called the trial of impeachment that is handled in the Senate, and he survived the trial, so he didn't lose his position, okay? Now, What the Constitution tells us is that there will be a Supreme Court and inferior courts as prescribed by Congress. So Congress determines the number of judges in the Supreme Court. It determines the different levels as established, right? So those are who are in charge. So for example, the first court has 6 members. The Chief Justice is John Jay, if you can remember the Federalist Papers. Second Chief Justice John Rutledge, who was also in the first court, was the lead person in helping with the drafting of the Constitution of the United States, right? James Wilson. So a couple of interesting members, characters in 1789. This will be during George Washington's court. Now, a few things that are notable. Number one, remember, the structure of the court is determined by the legislative branch. Now, quick question: which court will I go to? And I like to give this question to students. And the simplest example I like to use is I'm annoyed, I'm frustrated by the day, so I choose to slap 2 people in order to feel better. One person works for the 2 people who show up first. I'm going to slap them. Happens to be mailman. One is USPS, the other one is FedEx. Now, all things being equal, there might be some acts of federal acts that support or protect mail carriers, but that's beside the point. Simplified example. A USPS worker and a FedEx worker show up, I slap both of them. Which court do I go to? A state court? Do I go to a federal court? How do I know which court I should go to? What's the difference? One of the mistakes that sometimes I see is that students say that it depends on the severity of the offense. So that lower issues go to state and more major issues progress up to the federal level. But remember, we are a federal country, not a unitary country. So in this case, it's my famous seesaw, right? And so we have the federal, the national government, and we have state governments. And it's a separation of powers between 2 levels of government. So there's state courts that deal with matters that are usually within the reserved docket. And the federal government deals with matters within the enumerated docket. And so each one of them deals with their own issue areas based on the power that they have. So if you commit a state crime, you can also be charged with murder. That's a very severe thing, right? Because that's under the state's reserved power. But if you commit a federal offense, you'll go to a federal court. So they're completely 2 different court systems. So in my example, possibly, right, in our scenario, USPS is U.S. Postal Service. That's a federal agency. FedEx, on the other hand, can be a private corporation, I believe. So in that case, maybe you go to state court for slapping a delivery person, right? While you go to state court by effectively slapping a federal worker, right? So you can end up maybe in 2 courts, right? 2 different courts, same offense, slapping someone, but in one case you slap somebody under the federal jurisdiction, in the other you slapped somebody under the state jurisdiction. However, you can commit a crime that is concurrently under both governments, so that you can pay the price and have to go to both courts to deal with the same issue, because they're not under the same jurisdiction. Now, with all that good stuff being said, let's go back to the history of the court. Right? 1789, we saw the court that was assembled. It was assembled based on a bill. The first bill to the Senate was the 1789 Judiciary Act that gave us the structure of the courts. It gave us 13 judicial districts, right? And they were organized into 3 circuits. Now, if you remember the constitutional compromises, they will follow the circuit. So there's the Southern Circuit, the Middle Colonies, Middle Circuit, and the Northern New England states, the Eastern Circuit. So those 13, and again, 13 states, right? And so that's what we had. They met in New York at the Exchange Building. Their first opinion, West versus Burns, 1791. That's the first case. Now, consequentially, the next thing to take note of is the Chief Justice John Marshall of Virginia the fourth Chief Justice chosen by the next administration, John Adams, the most consequential federal judge in American history, because he will set such an important doctrine of judicial review, which we'll learn in a moment. All right, so the members of the court. One of the things I say is that most of us are unfamiliar with the federal court system, and mostly the members of the Supreme Court at the very top, okay? And the reason being is because the courts are insulated, right? We don't broadcast them live. We don't have cameras and photographs of their procedures. This is because they believe this will cause bias. It will cause public pressure on the courts, and their job is unique and peculiar, as they will say. And so we'd like to protect and isolate the courts. In other countries, they can do that, but in the United States, they don't think it's fitting at the federal level to bring in then that's why, and then they don't run for office, right? So we don't really see them. So you can pass by a federal judge, or rather a Supreme Court judge, who is a very consequential person based on the years that they serve. Currently, the court leans, we have what we consider liberal judges in their judicial philosophy and conservative judges in judicial philosophy. There was a liberal judge who did not retire, and so she passed away in office and was replaced by Trump, and therefore that gave a supermajority. So on the conservative side, there are 6 members who are conservative, and on the left there are 3 members. That would mean that if cases came before the court, there's a higher probability that all cases will be interpreted from a more conservative judicial philosophy than a liberal judicial philosophy of law. All right, I'm not going to go too deep in the courts, but one thing to just note. If Trump gets to replace 2 judges, he has already he has had the privilege of having 3 judges in. That's Amy Coney Barrett, Kavanaugh, and Gorsuch. If he gets the ability to replace Clarence Thomas and Alito, who are now older and aging, and they accept him to replace them, Trump will have, I would argue, the most replacements, significant replacements in U.S. history. There are others who have replaced more people. George Washington, of course, because again, he's the first president, so he's going to input all these fresh new judges. You have FDR, who served 4 terms, who had a lot of judges, but within 2 terms of 4 years, if Trump gets to replace 2 more judges, then I would argue that per capita and all things being considered, he will have the title of the greatest influence in American judicial selection. All right, so we'll see how that goes. All right, and so when you look at the judges, a judge affects you for a very long time. We've not changed the number from 9 since 1869. And so if he chooses the next leader, the college students who are like, let's say if you are a college student, or maybe even a senior in high school, if he chooses the leader now, by the time that new judge leaves office, you will be in your 50s, right? Supreme Court judges serve for 30 plus years. And so if everything is equal, you know, they'll affect you, they'll affect your children, they'll affect your children's children. That's how powerful and how long a Supreme Court judge or federal judge affects American public policy. Therefore, there have been calls to put a retirement age. Maybe they should serve 15 years. And after 15 years, they should give room for new and other jurists to also come in to the court. Now, as far as the numbers, they've changed. As I showed you, we started with 6, went down to 5 in 1800, went back to 6 in 1801. Then we see Jefferson taking it to 7, Andrew Jackson to 9. The Republicans during the Civil War pushed it to 10. Basically, increasing the number of judges helps you, again, protect your judicial or your policy preferences. It's called political insurance. All right. Now, there's a map that can be examined. I'll start with the district level. how cases start. Remember, the district courts are the trial courts, courts of original jurisdiction. In states, states have districts. So if you take a state like Texas, there are 4 districts, right? So Roe v. Wade, for example, starts from the Northern District. So if you break federal law, you'll go to either the Northern District or the Eastern District, or maybe a Western District or Southern District, right? That's where you're going to go to the federal court. And, you know, there are district attorneys who have been nominated by the president who serve there. There are district judges who have been nominated by the president who serve there. And that's very different from maybe the state level. And so if you see the state on the other side, you can see that at the state level, that is the appellate level. So we start at the counties, the small boxes, and then we make ourselves to the appellate level, all right? And so state court system is different, all right? So we start there, and then you appeal up, we go to the Fifth Circuit if you're Texas, right? So Fifth Circuit Court, that handled Roe v. Wade, that also handles the Dobbs-Jackson case that overread Roe v. Wade, both handled in the Fifth Circuit Court. That's the Fifth Appellate Court, right? And then finally it goes to the Washington, D.C. So you can see spread across the whole country are there different circuits, with each circuit having an appellate court. And then after the appellate court level, it goes to the Supreme Court, which is housed in Washington, D.C. The Federal Circuit Court is housed in Washington, D.C., and the D.C. Circuit Court is housed in Washington, D.C. All right, so again, 94 judicial districts, all right? Because of their caseload, they can be helped by people called magistrate judges who are appointed for office for a certain amount of years, maybe 4 part-time, maybe 8 years full-time, if they're full-time, and so they help district judges deal with all the cases. Again, there are 13 appellate courts spread across America, moving up, and then the Supreme Court with the Chief Justice being the head of that court. A few terms: the writ of habeas corpus, the right of going before a judge. We don't believe in detainment without being presented before a judge to be examined. And that shows us that in this country, that's what we believe in. And that right has typically been extended to both citizens and non-citizens, both documented and undocumented people. Precedent is a final decision on a case that is held, and other future cases base their decisions based on that prior case. So that's precedent. So if you go Plessy versus Ferguson in 1869, a reaction to the 13th, 14th Amendment and the changes in the freedoms and the liberties and protections for the African-American community, Plessy versus Ferguson comes in with all these Jim Crow laws that follow that are supposed to suppress this. So we're going to give equality, but Plessy versus Ferguson was a case in which Plessy, who is 7/8 white and 1/8 black, tries to sit in a train car for white people, and he is kicked out, arrested, goes to court in order to argue that there is no such thing as separating. However, unfortunately, the judges, only 2 dissent. The rest say that Plessy was on the wrong and that there's nothing wrong with separation. And that continues all the way to a precedent is changed in 1954 in Brown v. Education, where it is found that separating people does create inequality. You cannot not have equality and separation. So precedent can change. We saw that with Roe v. Wade, right? 1973, Roe v. Wade comes in, abortion comes in, but Dobbs versus Jackson case reverses that. All these things come from the Judicial Act of 1789 that I mentioned, that sets up the structures of the federal judiciary. So the 1789 Act creates the structures of the judiciary. Then there's the election. All right, we have the election that comes in the 1800s, and the election where John Adams is not going to win a second term. So what does he do? They passed a judicial act the same year, and that judicial act creates a whole bunch of judgeships, and Adams proceeds to input his people in different positions of the court. And by doing so, he is doing what is called political insurance. He's creating all these courts so because he knows he's leaving power, believing that all these new judges that he appoints will help protect his policy preferences. All right? So this happens. Then Jefferson comes into power. Jefferson's administration is quite annoyed at the fact that John Adams, the second administration, will create a whole bunch of judgeships on their way out, and even on the very night he's leaving office, he's signing people and placing people rather in different offices in the judiciary. So his Secretary of State, Madison, Jefferson's Secretary of State, Madison, who would become President number 4, blocks certain people from taking the appointments. So these people have been nominated, they've been accepted or approved by the Senate, but they need a letter, their commission letter to be sent to them in order to take their positions as judges. It's argued that Madison is withholding these letters. One of the people who has their letters withheld is a gentleman called Marbury. So Marbury is annoyed, but what Marbury has is the 1789 Act that created the structure of the judiciary also gives the right to go directly to the Supreme Court for certain cases. One of the things is to seek a writ, to seek an order from the courts compelling the government to do an action. And so Marbury versus Madison, to seek a writ, mandamus, to get this new administration to give him his position. Now, it comes before the Chief Justice John Marshall that I mentioned. And so Chief Justice Marshall is between a rock and a hard place. In one way, he's been appointed by Adams, just like Marbury, and he knows Marbury has the right to take his position and that his commission is being withheld illegally or unconstitutionally. At the same time, he doesn't really want to confront head-on the new Jefferson administration, right? So what will he do? So they seek the relief from Article 3, Section 2 of the Constitution. Now remember, it is the 1979 Act that gave Marbury the right to go before the court. But there's also the Constitution of the nation. Marshall's court argues, according to Article 3, Section 2, that the Supreme Court has original jurisdiction on cases affecting ambassadors, public ministers, consuls, and states. All right? They have original jurisdiction. On everything else, they don't have original jurisdiction. Now, is Marbury an ambassador representing America abroad? Or a consul? No. Or a public minister? No. Or a state representative? No. Therefore, the court does not have jurisdiction to listen to his case. And that's how he's able to get out of this. And what he argues is the 1979 Act that gave him the right to do so was in violation of what the Constitution just said. While the Act gave him the right to come to us, the Constitution does not give him the right to come directly to us. And therefore, which one is superior? The Constitution. Therefore, this Act, the area of the Act that had given him position, is annulled, is ruled by the courts to be unconstitutional. Now, why is that even necessary and important? It's because the court had just reviewed, judicial review, an act of government and declared it unconstitutional, therefore giving itself the power to be the ones who interpret the Constitution. And therefore, when maybe Trump signs an executive order saying that birthright citizenship is over, the courts can say, no, that's unconstitutional, or yes, that's constitutional, right? All this power and the consequences thereof after, right? Roe v. Wade, Lawrence v. Texas, Plessy versus Ferguson, Board of Education, all these court cases, the ability of judges to do what they do, which is the ability to look at the Constitution and determine whether government action is correct or not, that comes because Chief Justice Marshall's court said that a law the 1789 Act, the passage of law that gave him the right to come to us was unconstitutional. Therefore, that part of that bill or that act of Congress is null and void, and therefore judicial review. Which creates two types of judges: living constitutionalists versus originalists. Originalist judges believe that you interpret the Constitution based on what it originally meant in the time that article or amendment was written. There are even more extreme ones who argue they're textualist. They interpret the Constitution based on what is written, not even what you intended it to mean. Now, living constitutionalists will say, well, in 1791, my dates are going off, but 1789, 1790, 1787, what did it mean to be with the people? Could women interpret what those men thought then, or African Americans? So they will argue, no, you have to interpret the Constitution based on what it means today. And therefore, originalists will counter and say, well, the Constitution is an enduring document. It's not supposed to promote change, it's supposed to stop change to promote a continuous order. Living constitutions will say, no, constitutions are to help bring change and evolve things forward. So that continuous push back and forth is what we see between these two types of judicial interpretation. So the living constitutionalists are on the left, the liberal judges, while the living constitutionalists are on the right. And therefore we can understand the Dobbs case better because the originalists, who are 6 to the 3 currently in the court, decided that the idea that abortion will be protected in the national constitution does not exist in the history of the court. Whether we go to the 14th Amendment in the mid-1800s, whether we go to the end of the 1700s in the passage of the Constitution, or even the Bill of Rights, we don't see anything in the texts, in the spirit of the law of the time, originally that will protect abortion. Therefore, the right of abortion is not expressed, stated power in the Constitution, and therefore it becomes, according to the 10th Amendment, the reserved powers of the state. That is the federal judiciary.